So the accused person herein was charged with the offense of stealing by agent under section 283C of the Penal Code, the particulars being that on diverse dates between June 2022 and December 2022, being an agent of Umesh Bojwani, stole Kenya shillings 600,000 from Yusuf Dakane on behalf of the said Umesh Bojwani. The accused person denied the offense, and in its endeavor to prove the charges, the prosecution called 5 witnesses. In defense, the accused gave us one statement and did not call any witness. So allow me not to go through the summary of the evidence. Let me go straight to the issues for determination. The court has indeed considered the evidence which was adduced by the prosecution and the defense. I've also considered the closing submissions by the defense. Before going into the substantive issues for determination, in submissions, the defense has submitted that the charge sheet is defective since the accused person is charged under section 283C of the Penal Code, which is merely descriptive without including section 268 and section 283E of the Penal Code. Under section 134 of the CPC, it stipulates that every charge or information shall contain a statement of the specific offense or offenses which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged. In the case of Bernard Ombuna versus Republic, that is Criminal Appeal number 7 of 2018, the Court of Appeal stated that it is right that an accused person is entitled not only to be charged with an offense recognized under the law, but also to be fairly punished with all the necessary particulars of the offense to enable him appreciate the nature of the charge against him and to prepare an appropriate defense. In the instant case, the accused was charged with stealing by agent under section 283C of the Penal Code, which states as follows: 283, stealing by agent, if the thing stolen is in any of the things following, that is to say, C, property which has been received by the offender either alone or jointly with any other person for any account of any other person. In this case, as per the charge sheet, it was indicated that on diverse dates between June 2022 and the December 2022, the accused person, being an agent of Umesh Bojwani, stole Kenya shillings 600,000 from Yusuf Dakar on behalf of Umesh Bojwani. The failure to indicate section 283C to be read together is 268 of the Penal Code could therefore not have rendered the charge sheet defective, since from the charge and particulars it's clear the accused person was aware of the charges before the court, the offense was known in law, and the particulars gave reasonable information as to the nature of the charge. It is therefore there is therefore no prejudice occasioned to the accused person by the said omission. In saying so, I am fortified by the decision of the case of Obedi Kilonzo Kiroro versus Republic, that is a 2015 Court of Appeal, where the court stated that the test applicable in determining the existence of a defective charge is whether the conviction based on the alleged defective charge occasioned a miscarriage of justice resulting in great prejudice to the accused person. Having determined the charges were not defective, to prove a case under section 283C of the Penal Code, the prosecution needed to prove the ingredients of stealing. In my considered view, the issues for determination therefore were: 1. Whether there was an agency relationship between the accused person and the complainant; 2. Whether the accused person stole the property within the definition and meaning of stealing under section 268 of the Penal Code; and 3. Whether the property stolen was received by the accused person in any of the circumstances as enumerated under paragraph C of section 283 of the Penal Code. In this case, the prosecution needed to prove the agency relationship between the accused person and the complainant. From the charge sheet, it's noteworthy the complainant has been named as Umesh Bojwani, who was PW1. According to the prosecution evidence, it was PW1 who had given the accused person the debt collection job. However, in defense, the accused disputed that and maintained he had been contracted by Profile International and not Umesh Bojwani. To substantiate this, the accused produced a letter given to him by Profile International dated the 26th of May 2022 as defense exhibit number 1. The said letter was clearly authorizing the accused person herein to recover a sum of Kenya shillings 967,700 owed by Yusuf Omar Dakane, it's therefore clear that any agency relationship between the accused person and it is therefore clear that the agency relationship was between the accused person and Profile International Kenya Limited and not the accused person and Umesh Bujwani. The prosecution did not produce documents linking Profile International Limited to Umesh Bujwani, such as a CR12 for the company, to confirm he was a director. Legally, a company is a legal entity capable of suing and being sued. The proper complainant in this case should have therefore been Profile International Kenya Limited and not Umesh Bujwani. On the second and third issues, under Section 268 of the Penal Code, it provides the definition for the offense of stealing as a person who fraudulently, without claim, takes anything capable of being stolen. In the case of Republic vs. Jones, the court observed that on a charge of theft, it's necessary to prove the fraudulent taking or conversion without claim, right? And the person is deemed to have taken or converted that property. So in order to prove this offense of stealing by agent, the prosecution needed to prove that the accused person as an agent stole money belonging to the complainant. From the evidence of PW2, he told the court that he gave the accused person a total sum of Kenya shillings 600,000, but the accused person only remitted Kenya shillings 130,000 to PW1. On his part, the accused maintained that the accused person had sent that PW2 had sent for him Kenya shillings 74,700 on his M-Pesa line and Kenya shillings 104,000 on his Airtel line, and he had deposited Kenya shillings 130,000 to PW1 after deducting his 30% commission. The accused in defense considered that the numbers 0722 92 59 49 and 0751 96 64 40 belonged to him. The court has therefore carefully scrutinized the M-Pesa statement, specifically in respect to the transactions between the accused person and PW2. In evidence, the accused conceded to he got Kenya shillings 178,700, which is even a figure higher than quoted by the IO, who on cross-examination stated that the accused person got Kenya shillings 164,700. Be as it may, the accused is charged with stealing Kenya shillings 600,000. Apart from the money evidenced by the M-Pesa, PW2 allegedly gave the accused person some money in cash. It's straight law that whoever alleges must prove. PW2 did not avail any documents showing the accused person had acknowledged any of the monies given in cash. Neither were there any witnesses who are called who saw the accused person receive the money in cash from PW2. Further in evidence, PW2 alleged that the accused person also received money from his employees, who are Franklin and Mohammed. However, they said the employees were never called as prosecution witnesses, and neither were their statements produced to confirm that the accused person had received any monies from them. This being the case, the only proven amounts that were received by the accused person was what was sent via M-Pesa, the total being Kenya shillings 178,700. From the letter of engagement given to the accused person by Profile International Kenya Limited, the percentage of the commission charged was not indicated. In court, PW1 stated it was 10%, while the accused person maintained the oral agreement was for 30%. In a criminal trial, the burden of proof never shifts to an accused person. From the evidence, PW1 confirmed he was with two other directors when they gave the accused person the job. I believe it would have been prudent to call at least one of the directors to confirm the oral engagement given to the accused person in terms of commission. This was never done. This being the case, supposing the court was to indeed adopt the commission of 30% as alleged by the accused person, this would entitle him to an amount of Kenya shillings 53,610 of the recovered money, which was Kenya shillings 178,700, leaving a balance of Kenya shillings 125,090. And in fact, the accused person remitted Kenya shillings 130,000 to Profile International Limited, which was above the Kenya shillings 125,090, which was to be subjected to his commission of 30%. Having considered the evidence in its totality, I do find the prosecution failed to prove the agency relationship between the accused person and the named complainant, that is Umesh Bujwani, and further failed to prove that the accused person stole Kenya shillings 600,000 as alleged in the charge sheet. Beyond any reasonable doubt, and as such I do believe any conviction will be unsafe. Consequently, I do find the accused person not guilty, and I proceed to acquit him under Section 215 of the CPC.
Mr. Blackstone, I do pray that the cash bill be returned to the depositor.
Very well, so you can have the cash bill deposited being released back to the depositor.
Most of them.